To be debating whether you should allow witnesses is to be debating whether you should have a cover-up, by definition.
Democrats refused to invite Republican witnesses and directed witnesses called by the Democrats not to answer our questions.
What you ruled was that he was a witness. You've just told us he wasn't a witness. My point of order is that you were out of order in your ruling.
But you know, today, I guess, is the movie version of the Schiff report. Except one thing, the star witness failed to show up. Mr. Nunez is here. His staff is here. The leading headline is there, Schiff report. But where's Mr. Schiff? And Robert Mueller testified. The Ken Starr report, Ken Starr testified. The author of the Schiff report is not here.
The point of order is not sustained. I've already ruled on it. He was not a witness.
This committee is not hearing from a factual witness. This committee is not doing anything past hearing from law school professors and staff. We've not been given, the chairman said something about the president not being able to come. Show me where he would actually have a proper process in this that's not talking to staff and not talking to law school professors, when we could actually have witnesses that will be called by both sides.
I've been a judge, and I know that you don't get to be a witness and a judge in the same case. That's my point of order. He should not be up here.
It's not a point of order.
This is a show. Unfortunately, today, the witness who is supposed to be the star witness chose to take a pass and let a staff answer for it.
There is no rule nor precedent for anybody being a witness and then getting to come up and question. And so
I have ruled
we would. The point of order is he's inappropriate to be up here asking questions.
That is not a point of order. He's here in accordance with Rule 6.6 with sustained.
I'd move to table this.
Did you actually call for a vote? How is it not sustained? You didn't call for a vote.
Sustain the point of order.
I sustained the point of order.
I call for an appeal of the ruling of the chair. Now you call for a vote.
I sustained the point. I ruled that the point of order is not well taken.
Well, that's painfully obvious.
Reserving the right to object.
We will now hear presentations.
Mr. Chairman, I appeal the decision of the chair.
There's no decision to appeal. There was not a ruling and a motion. We will now hear presentations.
A ruling on the point of order.
You made a ruling on the point of order.
Yeah, you made a ruling on the point of order, Mr. Chairman. You can't then not allow us to appeal the ruling of the chair.
The gentleman will suspend. We are doing what we have to do under the rules. We will now hear presentations of evidence.
Mr. Chairman,
the gentleman is not recognized. We will now hear presentations of evidence.
I have a parliamentary inquiry.
I haven't removed my objection yet.
I will not recognize a parliamentary inquiry at this time. We will now hear presentations of evidence from counsels to the judiciary.
Is this when we just hear staff ask questions of other staff and the members get dealt out of this whole hearing? And for the next 4 hours, you're going to try to overturn the result of an election with unelected people giving testimony?
Gentlemen will suspend.
And we're happy to respond to questions.
Let me add something here. I just want to add that this fixation on the Clinton precedent is weird. The Clinton trial was conducted fairly. But distorting what happened there shouldn't make a difference. The question is, should you have a fair trial now? Any intelligent person knows that in any trial, whether it's for robbing a bank or for subverting the Constitution of the United States, the accusers, in this case the House of Representatives, bring in all the witnesses and all the evidence. The defenders can bring in all the evidence they want. That's how you have a trial. To be debating whether you should have the evidence admitted, to be debating whether you should allow witnesses, is to be debating whether you should have a cover-up, by definition. There's no other way to look at it. It doesn't matter how it was done some time ago. It was done very fairly, as it happened some time ago. But it doesn't matter. It cannot be used as an excuse. The only reason to oppose bringing a witness is to cover up because you're afraid of what the witness will say. The question before the Senate is, do the Republican senators want to be complicit in the cover-up of the president? Any senator who votes to deny a witness, who votes to deny evidence, is voting to cover up the president's crimes and subversion of the Constitution. There's no other way about it. There is no conceivable reason to deny witnesses, to say you cannot bring in the evidence, the House of Representatives cannot bring in the evidence. There's no reason. I mean, it's obvious to say, what do they fear? Why won't they bring in the witnesses? Because they are afraid of what the witnesses will say. But there's no trial in this country in which you wouldn't admit the relevant witnesses, in which it's even a question